Okay, good afternoon, everyone. I guess we're going to get started on our next, this is a breakout session, my name is John Fay. I'm an attorney and general counsel with LawLogix. We are a software provider. We do immigration compliance, we do I-9 and EVerify related software. Before that, I was a practicing immigration attorney. I spent a lot of my time actually doing I-9 audits, getting involved with EVerify registration and so forth. And just to let you know, today is actually my birthday. I mention that only because I want you to know how dedicated I am to I-9 compliance. I'd much rather be out there frolicking about. But I'm going to hopefully guide us through today in a really deep dive into the I-9 compliance world. And I'm very lucky to have Kristin Taylor with me today from Appleman, Leiden, and I'll let her do her introduction.
As John said, my name is Kristin Taylor. I'm an immigration partner with Appleman in Leiden, and I focus primarily on corporate immigration, but probably about 30% of my time is also dedicated to compliance issues such as I-9, EVerify issues, public access file issues, Office of Special Counsel, those types of matters. So I'm pleased to be here today to talk about the new I-9 form along with John.
Great, thank you, Kristin. And I think it's just important to know, we've been talking a lot about big policy issues today, a lot about very abstract ideas, certainly related to the new Senate bill. And so what our session is going to be particularly about is really a very concrete, this is the I-9, we've been talking about it so much, now you're actually going to see it. You're going to get to see it in its latest, newest form. And we're really going to dive into a lot of the different issues that employers are facing today. Hopefully it will be instructive. We have a smaller group, of course, because we do have another breakout session going on. So if you do have questions throughout, I recommend please get up to the mic. You don't have to wait. We can make it as interactive as possible. So this is, by the way, this is a Prezi. If you haven't seen this before, it's a Zooming presentation. Things are going to be shifting around. So don't worry. It's not like you ate something funny for lunch. It really is kind of interactive. So I hope it propels this conversation a little bit. So as Dan was talking about, just in terms of I-9s, we saw the data. And if you think about it, the I-9 is the most completed federal form that is not actually filed with any government agency. There are just so many of them out there. So I think it really deserves a very, very deep dive. So we're going to take our first kind of peek at this. And we'll talk, you've heard a lot today about I-9 compliance in terms of what it is today. I thought it was instructive just to take a step back and think about what it used to be and why we even care about this. So certainly, I think many of you know, in the past, at least when the I-9 was first introduced, there wasn't a whole lot of actual education. There wasn't a lot in terms of enforcement. And then we saw that shift in the kind of mid-90s and also the 2000s. We started seeing what we refer to as kind of a raid approach. This is where you have very high profile, very highly expensive operations by ICE. And to a large degree, they were very expensive and not entirely effective. So since 2009, we've seen a very different shift in the way I-9s are being prosecuted and in the way that they're being handled. Many refer to this as the silent immigration raid. And it's through paperwork violations. It's through this civil penalties. And that's what we're going to be talking about a little bit today as we dive into the I-9, but I just think it's important that we think about it in the broad context, because otherwise you're just like, well, who really cares if I didn't dot my I or cross my T in this particular location? So again, that's one of the things that we've been noticing sort of at a broad perspective. And if you look at this, again, the numbers in terms of percentages seem eye-popping because they really weren't very large to begin with. So now all of a sudden we're having a 600% increase in notice of inspection. In terms of the numbers, by the way, fiscal year 2012, it was locked in. There was 3,020 I-9 audits that were conducted by ICE. We certainly expect that will continue. If you talk to anybody from ICE, they say, well, our strategy is going to remain the same. We're going to prosecute people who are taking advantage of unauthorized workers. We're going to be prosecuting people who are hiring unauthorized workers. We're going to be doing more paperwork audits. We're going to get people to try to join our image compliance program. So a lot of this is really going to remain the same. Another thing to take into account, and I think we were talking about this a little bit, but this is really what we refer to as kind of being between the rock and the hard place. We've been talking mostly about enforcement so far, right? We're talking about ICE, coming you. We've heard guns and badges a few times today. So there's also the other side, and that is the Office of Special Counsel, which is part of the Department of Justice. And they're more concerned actually about workers' rights. And so what we've been seeing a lot, especially during the last 2 years, are an increasing number of settlements with employers in instances where they've actually gone too far. This is a cartoon which we kind of blown up a little bit here. And it's not to say that this necessarily happens even during the application process, but it's just one of those things that if you look at any of the Office of Special Counsel cases in terms of I-9 compliance, one of the biggest problems we see time and time again have to do with green cards. And we can get into a little bit of that later on as we dive into the I-9 form. And then, of course, we have a brand new I-9 form. I mean, that in itself is momentous because it's, number one, it's doubled in size in terms of the amount of paperwork that you need to complete, but it largely hadn't changed over the last 25 years, just minor indications here or there. So again, super important in terms of if you're in the I-9 compliance world. The I-9 geeks were kind of jumping up and down when they heard that there was going to be a new 2-page form. But it kind of begs the question. It's like we've been talking about how difficult I-9s are to complete, all the potential liability. Why do we even have a new form? Why did they take it upon themselves to make our lives so much more interesting? So Kristin, can you enlighten us as to why do we have a new I-9 form?
Well, quite simply, the form expired. The older form, the prior form expired and was definitely in need of revision. It was error-prone. It was very easy to make mistakes on the very simple, they would say, 1-page I-9 form. And with the new 2-page form, there has been, some improvements to the form to help reduce some of those errors and mistakes, particularly in conjunction with the new handbook as well as the new instructions. They've made it a little bit more user-friendly in that it has more space on the form, as we'll see as we go through the presentation, and it makes it less difficult, I would say, for an individual to record a document perhaps in the wrong box or put something on the wrong line. So that's, two reasons, I guess. And then thirdly, we've heard a lot about the mandatory EVerify that could be coming that's in the new bill. And that's another reason why they have revised the form, as well as we'll also talk about the automated I-94 and to account for some of the technological advances that the agency is making.
So we understand we have this new form. It's coming out. It's already out, actually, and it's going to be absolutely required as of May 7th. So if you haven't already taken that down, as of May 7th, you need to be using this new I-9 form. But Kristin, here's another kind of follow-up question, and this is kind of very broad, but do you feel like employers are better off? I mean, once they actually start getting used to, acclimated this form, is this good news for employers, the fact that we now have a 2-page I-9 form?
Well, I think you have to take the good with the bad in this instance. I think someone alluded to the increased processing times and the burden that has been placed upon employers by completing the new 2-page form, but there are some good features, as I mentioned, the fact that it's provided more room, there's more clarity in terms of where to list document titles and the instructions, so there are some good things to take into consideration, and the fact that there's more room for data entry and that it's cleaner, but it is quite burdensome in terms of document retention, more paper if you're on a paper process that you have to retain. So it's good and bad. Yeah,
and I think that's really a profound reality, because we talked about how many people are currently not doing the old I-9 correctly, and now we've been mentioning additional burdens that might come with a new immigration bill, but this is actually a new burden which has already arrived. It's something that employers are already grappling with. So if you're an employer, if you're an attorney who's advising, this is a huge opportunity and a time for you to really start paying attention to how this works. And so we'll go into that a little bit. Obviously, now we've sort of answered that question to a large degree. I prepared this a little while ago, but certainly EVerify is so coupled and so tightly integrated with the I-9 process. So you really cannot think about one without the other. Today, I think we'll be talking a little bit about how EVerify is impacted in terms of the new I-9 form. It is a little bit. We're going to see additional EVerify changes that are going to be coming up actually later this fall in terms of really major changes that from what we've heard. So again, this is something that you really have to think about both of them together. And the map, by the way, is something which has frustrated many people because it's just you have so many different EVerify requirements right now depending upon the state you're in, or in some certain locations it's the city or the county. Now a lot of that might go away with this new immigration bill, but in the meantime it's something that we all have to address, we all have to deal with. And I think to a large degree employers probably want to even think about, well, gee, should I start getting on the EVerify train now, the runaway train, because eventually it's going to hit me. So again, we'll talk about that as we get into this. So here's our little, yes, we have a problem. And as I think we've been talking about, liability is certainly one of the key issues that we need to think about in terms of dealing with an I-9 form. By the way, the reason I'm standing over here is I didn't want to do the whole neck cringe thing. So I did actually bring a little rear view mirror, but it didn't work. So I'm just going to stand over here. So another thing I think you just have to analyze as you look at any kind of I-9 compliance, you have to think about, okay, well, what are the fines? What have we seen out there? How can that help me? Is it instructive? Does it help me make a better I-9 compliance program? Does it help me build the better business case in case I need to actually revamp my processes, in case I want to hire somebody like Kristin to do some auditing for me? So we can take a quick look, and I realize this might be somewhat small, but this is just a recent sampling. And I think it's interesting to note that a lot of these are, some of them are settlement agreements, some of them are actually instances where you had unauthorized employment, but actually there's several where there were actually no instances of unauthorized employment whatsoever. So in other words, these were entirely technical procedural violations. That, there are a few that just ring out. There's this blueberry grower, the Jasper Wyman & Sons, $118,000 purely just for technical violations. And that was, again, a settlement. So who knows how they started, who knows all the different fees and fines they had or in terms of costs and actually get to that stage. So again, these are very important things to recognize as you're trying to build the case or even understand your I-9 compliance obligations. So, it's one of those things. I like to have an I-9 scrapbook of horrors. These have changed over time. We take a look at this, and I think to a large degree, some of these things will change a little bit. The form has gotten a little bit better. So these are actually, some of these are from my colleague, Wendy Madden, so I have to thank her for these. But these are based on real ones here. Obviously, Fox Hills Golf member is not a valid List C document. We have our SS card is in the wrong spot. I think that's actually that type of error might actually change a little bit under the new form, but we'll have to wait and see. Cannot read, that's not really a good idea. I mean, okay, great. At least you took a document, but if you can't read it, that's not something you want to accept. I think I have another one here, but I'm actually going to have to do a little bit of a walk to go to my Prezi here just to show you this. But we also have just a little bit further down. Again, this is, real life. I couldn't make this up. And this is where we talk about the danger of the Post-it notes. I mean, great. Thank you for just documenting that for me. I also want to take a quick note of the DOL, GADOL. And you think, okay, Department of Labor, why did we record that? It's actually the Department of Licensing, and it was on the Georgia driver's license. But do you actually want to have that recorded on there? Do you want to raise that potential issue where ICE is going to say, no, that's not valid? And there's an actual real case from Okaho where this came up. So again, you have to recognize all the different rules and procedures. I'll do my walk back over here. In terms of abbreviations, that's one of the things that they've said many times. Yes, you can abbreviate certain things. You can do DMV for Department of Motor Vehicles. But be careful in terms of these somewhat ambiguous types of abbreviations. Okay, so we're going to take a step out of here. And we'll take a look at kind of the old versus the new form. And I think this is important, again, just to sort of see like where were we and where are we now. So the one on the left is actually now what we consider the old form, prior version 87-2009. And some of the things that you'll notice in particular is they've made the form a lot more official looking. So now we're on the right side here. We have the new Form I-9. We have the DHS seal. which you think, okay, just a cosmetic minor thing. But I actually think it's important only because you have a form which many times people just don't realize how significant it is. They don't realize that they're actually signing under penalty of perjury. And so by the fact that we have a seal, I'm actually hopeful that people will take this from a kind of an importance perspective. Hey, this is an I-9 form. This is a government form. We need to pay attention to this. So in addition to that, we have a variety of shadings. We have boxes. We'll get into that a little bit. The biggest thing, which you can't really see here because it wouldn't fit on my screen, is the fact that obviously we have a 2-page form. So we're just actually showing you page 1 of the new I-9 form. So, and we're going to go into this quite a bit. But just as sort of a practical question, we've been talking about here, we have the new form, and the new form also has instructions to it. And the new form also has a list of acceptable documents. Now, Kristin, this is something I receive a lot in terms of questions. We have a new form. Oh my gosh, I have so many pieces of paper I need to retain now. Do I need to retain, for example, all the instructions and the list of acceptable documents with every single I-9 I maintain?
No, the employer is not required to maintain or retain the instructions along with the 2-page form. You're only required to retain the data, the 2 pages that you actually fill out the form on. And so that's all that's required for retention. But what's important to note is that it's very clear now that you are, as the employer, to provide the instructions to each employee that you are completing an I-9 for. And they make that very clear in the instructions that each employee is to have the instructions when they are completing, Section 1 of the I-9.
And how about, actually, someone just came up to me at a conference recently and asked me this question. Could I laminate, for example, the instructions? Because I want to make sure they're not changed, they're always available. Maybe I have a process where someone's always going to be sitting in this seat as they're completing the I-9. Is that something that you would...
I would advise it. I think it's perfectly acceptable, and even in the handbook, I think on page 27, it states that you could do double-sided. So if you're not wanting to have all the full 7, you could do double-sided pages of the instructions and laminate them so that it's easy to have and readily available for your new hires as they complete the I-9.
Great. So now let's start to take our deep dive. So here's actually, now we're looking at the new Form I-9, pages 1 and 2. And so we're actually going to go very, very at the top here. And I want to talk about some of the things that have changed, why they're important, which ones may not be so important. So as kind of take a step back, the form was actually introduced back in March of 2012. It took almost an entire year for them to actually review all these comments, to come out with additional ideas, and then finally actually complete the form for its initial publication, which was March 8th. So we've seen things change over time, and I can go into that a little bit. But some of the first things you'll notice is last name, first name. We now have family name and given name. And you're thinking, okay, well, that wasn't there before. Do we really need that? And just to give you a little kind of useless trivia, under the originally proposed form, they actually had that reversed. They had family name first, and they had last name, but people were saying, oh my God, that's really going to confuse people. But what this is about, obviously, certain foreign nationals sometimes who may actually have their last name be their given name in terms of actually how they order it, in terms of how they're used to providing it on government documents or actually used to completing it. So it's intended to provide them with a little bit guidance in terms of what should be completed here. In terms of auditing the old forms, I've seen many, many times where you have the last name has been reversed, it's been put in the first name. Is this going to completely solve that issue? I don't necessarily think so, but it's okay. I mean, this is at least one little minor change that you might see. I don't think it's going to be a big hang-up. Now, in terms of one thing which has definitely changed is we used to have maiden name, and now we have other names used. And Kristin, if I could just ask you, what's the significance behind that? Is there anything that you would be concerned about or anything you would advise employers about how to treat that field? I mean, do I have to put, if I have 3 or 4 or 5 different names that I've used, do I have to fit every single one of them in that field?
I would advise that the employee do list any other names that they've gone by or use in that, and not just maiden names, particularly if the employer is EVerify. So I would list those names there.
Yeah, and it's interesting. I mean, if you look back, it's like, why did they change this? Are they really trying to get to all this information? And before, it was Maiden, and so I think a lot of the comments were, well, let's get something a bit more gender neutral. And so that's where, this originally started. But now, of course, you have this issue. It's like, well, gee, I actually do have a whole lot of other names. So you could certainly choose to do that. It is an optional field, as it always has been. But again, this is one of those things that you have to sort of become accustomed to in terms of dealing. Now, I should note that behind all of these are additional instructions. We have 6 pages of instructions. So we now have additional guidance about how to complete, for example, when you have a hyphenated name. They say to actually include that. Or maybe you have 2 last names. They now indicate very clearly in the instructions to do that as well. And you're thinking, okay, well, I guess I understand that, but is there any significance behind it? And the significance, I would suggest, has to do with EVerify. Because EVerify is, again, taking all the information from the I-9 form and it's submitting it through. And if you're familiar with the EVerify system, it can be very finicky. It can be very picky. And so one of the things that we've seen over the years is with a high number of tentative non-confirmations when you didn't have both names in there. So now they're trying to get that finished, kind of get that solved earlier in the process. So now we have that instruction there as well. Address, street number, name, apartment number, city, town. Again, these really haven't changed a whole lot. I think some common things that we do hear about is it's much more clear in the instructions and also online that P.O. boxes are not acceptable. If you ask USCIS, they say they've never been acceptable. But meanwhile, we know over many years we've dealt with certain ICE agents that said, okay, it's fine. So now I think we have more clear guidance. So certainly if you're in the practice where you've had instances where somebody was temporarily employed, actually just relocated or reassigned, and they're like, well, I'm just going to use a P.O. box because I don't really have a physical address yet. They actually do want you to include a physical address. If you don't even if you're sitting out in a hut somewhere, they say, okay, the corner of, Left Street and West, near the Rock. I mean, really, they just want a physical description of an address there. So it's something to keep in mind. In terms of social security number, we have more formatted boxes. Again, this is minutia, right? I mean, now we're really, really into the weeds. But the reason behind this, again, is all the different times that is missed. That you have a social security number that wasn't properly formatted, and then you have ICE show up at the doorstep, and naturally they're going to run that social security number through their systems, and now they don't have it. They have to go back to you, and you're in a situation where you're like, oh, well, now I got to complete this form. I have to actually correct it. So that may change a little bit. We'll have to see. And then I think the ones that have gotten the most attention in terms of this new form are the email address and the telephone number. So, Kristi, I have to ask you, I know it's been asked so many times, but why, oh why, do they want the email address and telephone number?
We don't really know, or I haven't heard. They have not provided an answer as to what they are going to do or why they are requesting an individual's email address or their telephone number. In some of the webinars that I attended, it was alluded to the fact that I guess during an audit, the inspector could ask questions of the employee. Perhaps it would assist with resolving tentative non-confirmations. But this isn't a form that is typically followed up on unless there is a notice of inspection and an actual audit or something of that sort. So, I don't know if this is something, in the future that they are wanting to use, but clearly it is optional and it is not required. And so, I know you and I, when we were preparing for this, we were talking about, well, would we advise our employers to put in their policy some type of encouragement or actually put in writing, leave blank. Or put not applicable. And this is an area in most of the webinars that I attended where actually one of the USCIS webinars did state that if you are going to leave it blank, they do encourage you to put, don't leave anything blank, to put not applicable so that they know you purposely viewed it and chose to not provide either your email address or some of that documentation. And in our discussions, I told John, I said, I'm not comfortable with going so far as to advising one of my clients to put in their policy, tell employees to leave this blank. I think it needs to be left up to the employee when they're completing the form. I'm just a little more conservative in my advice. Even though it clearly says in the instructions it's optional, I think the best approach to take on this, or the safest course of action, would be leave it up to the employee as to whether or not they want to provide this information. Just make it clear that they know it's optional, that it's not something that is indeed required. Perhaps if they do feel inclined to give it, they could utilize their work email address and their work telephone number.
Yeah, and I agree with that. And it may seem like almost like a silly question. It's like, why are we spending so much time on two little fields which somebody may actually ask about? Well, again, I think you have to think about this on really a macro level. I think, as we've heard a few times today, we want to make employee onboarding, we want to make this process as smooth and as quick as possible. And if this is something which is going to cause your new hires to say, well, gee, what do I put here? Do I put my home address? Do I put my work address? Do I have to tell you if my address changes? You want to basically forestall all of those questions and have a policy right up front that you can tell them, so that you can tell all your people who are completing I-9 so they know ahead of time. Again, a lot of this is minutia, but it is important to have those policies in place to make this as efficient as possible. And I think the use of the NA is definitely a little bit of a red herring, at least in my opinion. I mean, the instructions are really, really poorly drafted, in the sense that you have, sometimes it says you may write NA, and in other fields it says you must write NA. And I don't think there's really any meaning behind that whatsoever. But I think it's important to note that, at least in terms of a best practice, some employers, you might decide, I want to have NA in all the fields because I want to make it super easy, as Kristin mentioned. So if you're looking at the form, you see which fields haven't been completed. But again, I personally don't think it'd be something I would necessarily lose any sleep over if I forgot to enter NA in the other names use field. But again, that's something that different people would have an opinion on. Yes, sir?
If you use EVerify, do you know how this is being entered?
So this information right now is not being required by EVerify. Now, we anticipate, they keep talking about, we want to contact the person in the event of a tentative non-confirmation. So, well, gee, how are they going to know that? Obviously, we're expecting the next version to probably ask for this information. As is typical with EVerify, there'll probably be, I don't have, not applicable. I would anticipate something like that in the future. Okay. So let's move on down here, and now we're in the attestation section, which has gotten much longer. They kind of stretched it out, and I think they did so for a reason. But just to kind of go through again what we see here, the 4 boxes haven't really changed at all. They are the exact same attestation choices. With the previous form, we saw the introduction of the non-citizen national. That's still there. One thing I do want to point out, and I'm going to ask Kristin about this in just a second, is the lawful permanent resident there. We have alien registration number / USCIS number. So, Kristin, I heard this question so many times. Is there a difference between an alien registration number and a USCIS number? And if so, why would anybody care?
Well, it's really the same number. So in some of the documents it says A number or alien registration number, but on the newer documents it's going to list a USCIS number. But they're one and the same number, despite the fact that in the instructions in this form does create some confusion. It's the same number.
Right, exactly. So, again, it's all about the acronyms. The government wouldn't be alive without acronyms, and so now we've got, A number and USCIS number. Maybe that will change. We'll have to see. Now, as we move on down here, though, we notice some really very different changes in terms of once we get to aliens authorized to work. So again, we have this was the same in terms of we have, the A number or the I-94 number. You might have individuals, for example, who have an EAD and they have an A number and they're able to provide that. You might have individuals who are in a work authorized capacity petitioned by their employer, and they've got an I-94 number, so that's an either or. But now we actually have these brand new fields down here. We have foreign passport number and country of issuance. But before I get to that, I do want to ask Kristin just a question, because I think this will kind of tie it all in. So, again, let's say I have a new employee who's coming to the United States. They're currently working abroad for my organization, so they're coming in maybe an intracompany transfer, the L1 visa. How would this impact this? Could you kind of walk us through what would change in terms of how this section would be completed?
For the intercompany transferee who's coming from abroad on their L1, they will be, at least as the law exists today, when they're coming over on the plane, they're going to be handed an I-94 arrival departure record, and they're going to complete that, and that's what they hand to Customs and Border Protection when they are inspected upon entry into the United States. And so it's in this instance where this form is asking for that individual to record the title, their foreign passport number, and the country of issuance. So it would be in that instance, not the instance of when the individual would be in the United States and your company perhaps extended their L1, where you have the tear-off version of the I-94 and kind of the I-797 approval notice. You wouldn't record it in that instance. And I do see that this is going to create, I think, some confusion, particularly for individuals who don't really deal in the immigration world and don't really know the distinction between the L1 approval that tears off on the 797 versus the white I-94, particularly with the introduction of the automation of the I-94, which will come into play in the later part of this month.
Yeah, and actually, I'd like to dive into that a little bit, only because it just seems like we're here. We might as well talk about it. At first, they were talking about I-94 elimination, and then it became automation. So now it's like, okay, I guess it's sticking around a little bit. So can you kind of walk us through just in a very high level, because I-94 automation has a lot of components to it, but just in terms of how it would affect I-9 compliance?
It's supposed to not impact it at all. So everything that the individual receives today on the white arrival departure record will be in the electronic version of the I-94. The difference is when they are at the kiosk being inspected, they're not going to get that cha-ching stamp and all of that stuff written and handed back to them. Instead, they're going to get a flyer or a brochure with a website that directs them to go to the website and says that they can then print out their I-94 that they will, of course, need to apply for Social Security number, driver's license, to complete the new hire orientation and complete the I-9. And it's supposed to be available the moment that they are inspected. There's not supposed to be any lag time. Now, of course, we'll have to see how that plays out as to whether or not, make sure the site is, always up and available. We don't want to run into those types of issues, but in theory, that's the way it's supposed to work, that it will have the date of arrival, their classification, the number, their country of citizenship, and the date that they're admitted, until. And so everything should not impact the manner in which that you complete the I-9 process for those individuals.
And actually, we knew this was coming for some time only, and again, to talk about how things tie in with EVerify. EVerify, way back in September of last year, they released a new version. And at that time, they started saying, you know what, if you're an alien authorized to work and you presented a foreign passport with an I-94 card, we're now going to ask you to send us the foreign passport number and the country of issuance. And we're like, okay, why are we doing that? But sure, we're happy to do it. And this is part of the reason why. Again, they're anticipating that they might not get the data as quickly as they need to from CBP, from the Customs and Border Patrol. So by providing this information, so anyone who's been using EVerify, you're probably familiar with this. In this particular scenario, you have to actually enter this information into the EVerify system. Using an electronic system, it works pretty much the same way. It just goes in directly. So again, these are kind of the nuances that we've been seeing in this particular part of the form. It really only affects a certain subset, but certainly if you do a lot of hiring of foreign nationals, I think this could be an area where you might have some more questions that you might have seen otherwise. So it's definitely important to take into account. As we're kind of rounding out this section of the form, I want to point out here the signature of employee. And you might think, okay, what's so great about that? But actually, before that, we did not have a box. So now we have a nice defined box where it says signature of employee, because I cannot tell you how many times during the course of auditing I-9s we've seen the signature is above the line, or is it below the line, and who really even cares? And the reality is, at least now, they say they don't care, but hopefully with this introduction, we won't even have this issue anymore. Who knows, maybe there'll be somebody who actually tries to cram their signature above the box, but hopefully not. So I think that's a good change that we've seen in the form. Another thing I want to point out, because again, it's always asked, is 3D barcode. What in the world could that be about? And unfortunately, just like with the the email address and the telephone number. We really don't have a good answer. The only thing we've been told is that it is essentially a placeholder for future technology. So, whatever that means. But, it could mean, for example, that they just want to actually start putting a barcode where maybe, they're just for control purposes. They know that, oh, yeah, they're using the right form. I scan that every single I-9 would have the same barcode. Or maybe, because immigration forms themselves have been changing, maybe the barcode is actually going to reflect the data that's on the form. These are just complete speculation. The only thing we know right now is do not write in this space. So that's the only thing that I can say in terms of that guidance. So now we're going to skip down to the bottom of this section, and this is the preparer-translator section, which is probably my least favorite part of this form. I guess to say the I-9 form in general, only because it's always tricky in terms of how to complete it. In fact, I'd have to say maybe section 3 is my least favorite. But in any case, this section here comes into play into a few different varieties of ways. And a lot of it has to do with, okay, is the new hire employee being provided assistance in any manner? Perhaps they are in another, they don't understand the I-9 form, so you're actually providing translation. Or maybe you're the HR person and you just need to give them a little bit of extra help. So when does this come into play? What we know for certain is if you, the HR person, are entering information for your new hire, then most definitely you are providing assistance and you should complete this area of the form. Now, it hasn't really changed a whole lot. What we have seen, and this is kind of consistent throughout the I-9 kind of redesign, is we've taken address fields and we've broken them out as much as possible. And I think that makes sense because if you look at the old form, many times address fields, if you just have one block for an entire address, it's just completely missed. So again, this portion of the form hasn't really changed a whole lot. It's still important. I think it's particularly important, though, in the context of electronic I-9 systems. And actually, I see a hand. Yes. Okay. Sorry. Save it for later. That's fine. So as I was saying, the electronic I-9 system capacity, and you might think, okay, well, how does this come into play? And the reason it comes into play is because if you're using an electronic I-9 system, many of them will integrate with other payroll systems, with HR systems, and they will essentially pre-populate areas of this form. Now, that might seem perfectly logical. It might seem, hey, might as well make it a little easier. My employee entered in this portal anyway. Why not just move it over there? And for many years, or I would say at least a couple years, when ICE has been asked, can we do this? Is it acceptable? They have stated, at least on once or twice occasions, yes, as long as you complete the preparer-translator section. So you think, okay, that's great. I had no idea how to complete the preparer-translator because it was the computer system that actually did it. So, but I suppose we can put the HR person there. But now, ever since this form was released, they've now said much more publicly and in several different forums that they actually don't want any pre-population whatsoever. They do not actually want you to be pre-populating the form. Now, is this something that's in stone? I don't necessarily think so, because there is no such thing as in stone with the I-9 form, it would seem. But certainly, it seems to be the way it's going. And I think once you start hearing high-level officials, I'm talking about top agencies or top officials within ICE, talking about no pre-population, eventually it's going to circulate amongst the group. So again, if you're using an electronic system, if you're considering it, there's certain areas where pre-population may be okay to do, but certainly in Section 1, it's definitely something you need to consider. Yes, sir?
Just noticing the state for both Section 1 and this translator drop-down.
Yes, it is a drop-down. So if you actually downloaded this form, it actually does list all the states in two-letter initials. So that is something that they've done to try to prevent improper states, for example. So that's pretty much how that works. They also do it the same way with the foreign passport country above. So they actually have a list of acceptable values. Another thing, since we're at the bottom of this form, again, it's just pointing out, March 8th, 2013, that is the new version of the form. The N, as in all immigration forms, just means that prior versions will not be accepted. And as I mentioned again, May 7th, you have to start using this form. They did give us a grace period from March 8th to May 7th. I should mention, by the way, that was actually a little bit vague at first. When they actually announced it, it was like, was it May 7th? Is it May 8th? Once again, it wasn't really careful drafting, but now we know it is May 7th. Oh, and actually, let me just go back here, one thing here. I'll ask this to you, Kristin, because we have graphics on this form now, but why the stop sign? Why did USCIS decide that we needed a stop sign on the I-9 form?
It's telling the employee as well as the employer, this is the section, this page is only for the employee to complete. The employee should stop with the little handy-dandy traffic sign that's now on the form, should stop there, and then the employer will take over on page 2.
Yeah, exactly. So, again, I think that's going to help ultimately. I was one of the people who was kind of kicking and screaming about making this a 2-page form, only because, you think about at the bottom of the I-9 form, we have the Paperwork Reduction Act, and here we are doubling the I-9 form. And in fact, if you actually look at the statistics, previously they estimated it took 13 minutes to complete an I-9. Now it takes 35 minutes to complete an I-9. And again, that takes into account reading the instructions, looking at the acceptable documents, and so forth. So again, I actually like the fact, though, that we now have a very clear delineation. So if you're completing an I-9 for somebody, page 1 is for the employee, page 2 is for the employer. Before, there's so many times where we do audits of I-9s, and you notice, let's see, section 1, that's done. That's funny. Section 2 is the exact same ink. Even the handwriting looks kind of similar, too. The people just keep on going down the line. So hopefully, maybe the stop sign will actually be effective. Okay, so now we're at page 2. So let's do our deep dive into page 2. And I'm going to jump all the way to the top here. We have our nice little shaded heading area here. And again, this section, just in page 2 in particular, I think is also extremely important. We were looking at those scrapbook I-9 of horrors, and a lot of the really terrible, really bad mistakes we see in the I-9 forms are also in section 2, which is surprising, of course, because you think, well, this is the employer section. They see this all the time. Shouldn't they be able to get this right? Well, they should, but it doesn't always happen that way, and there are a lot of good reasons for it. But one of the things that we've seen, just a slight little change, and it's hardly even noticeable, is in the instructions where we're always talking about list A, list B, list C. And of course, if you're all familiar with I-9 compliance, and I'm sure you are, you already know the rule that, well, we can accept one document from list A or one from B and one from C. But now they've actually inserted the word a combination of one document from list B and one from list C. Again, not a huge change, but it is something to serve as a reminder because, again, a very, very common mistake that we see, and one which is oddly difficult to correct only because there's no real guidance about how to correct it, is when you have all 3 of them filled out. So, again, whether or not that'll actually play out in terms of will it change, it's hard to say, but that's something that's new. We also have, hey, look again, we have the employee's name, it's back. So not only on page 1, but we also have it on page 2. Kristin, why do we see this field here?
Well, they're wanting, of course, you to be sure you match page 1 with page 2 to keep the appropriate pages with the correct employee. Now, of course, one way to avoid that would be to print the form double-sided, or even better, go electronic, and then you won't have this issue or that problem. But keep in mind there are penalties. The liability lies with the employer, and the employer is responsible for maintaining a complete I-9. So you really want to get some best practices in place for your company to ensure that pages are kept together so that you don't have incomplete I-9s or mismatched I-9s if someone forgets to put the name on it and it's not double-sided or you don't have an electronic program.
Yeah, that I think is definitely a big worry, is you're going to see all these half and I-9s out there once that we have a 2-page form, unless you do that double siding, which I think is definitely a good idea. Now, as Paul Virtue mentioned this morning, obviously he was the inventor of the infamous Virtue Memorandum that talked about actually how we deal with certain errors on the form. And right now, that is now going to be clearly outdated because we have fields for which there's no guidance about whether or not if they're left blank. So what happens if this is left blank? We don't know exactly. It just seems like it's common sense that you want to try to complete it. I think in the initial draft, it was a little bit unsure of, well, gee, does the employee need to do this? And so they actually moved it down a little bit in terms of where it was located on the page. But again, it's fairly simple. It's just the idea that you want to be able to say, this page 2 goes with this page 1. So that's that. Now we're going to shift down to the different lists. And the one thing that I have to say so far is, of course, while it's definitely really expanded, and I think we have a lot more room, which definitely I think is probably good for the most part. So I think just in terms of noting what's important here, what's changed, one of the things, and I think this is why I indicated in terms of that I-9 scrapbook of horrors, they've actually moved over document title, issuing authority, document number, expiration date. They've repeated it on list B and C. And you might think, well, that's kind of common sense, but actually it wasn't there before. So many times what we would see is somebody would complete a B, they would complete a C, and they wouldn't provide all the information, or they would put it in the wrong box. So hopefully this is something that will change, that we won't have that issue anymore. But I think if anybody's looking at this form and thinking what's new, what's changed, what's important, what they're going to notice is the list A box, which now seems terribly long. And almost like somebody got a little crazy with the cut and paste because we got multiple things over and over again. So Kristi, could you walk us through why do we have so many boxes under list A?
Okay, so many of you who have been tasked with either writing in the margins, if you have a paper, tiny little things, probably welcome this extra room, because if you have an F1 student and they're presenting their foreign passport along with their I-94, you now have a block to enter the foreign passport, you have a block to enter the I-94, and let's say this F1 student student does not have optional practical training yet, they have their curricular practical training. So it's on their I-20, if you will. And so now you have another block. So you have 3 spaces to capture all 3 fields. Or if you have a J1 intern, same thing with their DS forms, you can record that document there. So it's all nice and neat, and you won't have to write in the margins as much. It's still unclear, for instance, if you have an individual who is on F1 and they received a STEM OPT extension on how you're going to record that information. Are you recording it in this section? Are you recording it in the re-verification section? And what do you have to write in terms of that? Or even in terms of an H1B or L1 that has an extension is under the 240-day rule. You still have some of those gray areas that you'll still have to contend with, but they did address, at least in the revamp of the form, where you can capture those types of data points and keep your form somewhat nice and neat.
Yeah, and I think overall that's going to be good. We've been asking for this for a very long time. It's too bad they didn't also adjust for some of the other kind of areas. There's still going to be people writing in that box, as you said. But oh well, I guess as long as they avoid the 3D barcode box, you'll be okay, because it is here as well. And in addition, I think it's also noteworthy that EVerify is also one of the very tricky areas. If you have F1 students or even J1s, it's not really clean, because EVerify actually wants their program expiration date. And you might think, well, I've got a passport, a 994. Wait, where can I enter my duration of status? And so it's not very clean yet in terms of the EVerify integration. Perhaps that's something we'll see in the next version, and kind of remains to be seen. But again, these are the types of things that we have to interact with. We do have 2 systems. If the new immigration bill actually comes forward, it seems like the I-9 is not going away. We're just adding on burdens, as was mentioned this morning. So this is essentially how this section is going to play out. Now, let's move on down, and now we're in the certification area. And the certification area is interesting because it's the same, but they've numbered it. So again, I think it's the idea is to show its importance. So you're really making 3 attestations. Yes, I've examined the documents presented by the employee. That's 1. They actually appear to be genuine. They were late. And number 3, to the best of my knowledge, they're actually authorized to work. So again, hasn't changed, but it is numbered. So just minor thing, but we are doing a deep dive, and that's about as deep as we're going to go with that. Now, in terms of the following thing, we have the employee's first day of employment. And the first thing that I'll note is I'm very happy, at least, that they've removed it from the little certification section. And I say that only because to have a field buried in the middle of a paragraph is just really, really not good forms design. And we saw again and again and again on the old form where that was missed. Hopefully now, it's still kind of a, there's so many things going on there. It still could be missed, but I want to concentrate in terms of the language, employee's first day of employment. So, Kristin, if you could talk about what did this used to say, and why does it say this now?
Well, it was previously read or was listed began employment on. And so now, it's more prominently displayed, and it reads now, as you can tell, first day of employment. And even in the prior drafts, it had read, I think, first pay for wages. Let me find it here, the actual wording. The employee's first day of work for pay. And due to some comments that it received, it made this revision in the final form that will become effective on May 7th to read as it does today. But in the instructions and in the handbook, it goes on to say that this is to be the first date that the employee receives remuneration or wages or pay, but is not listed on the actual form. There were also, I think, lots of cheers from employers on this when someone has a future start date or hire date that is no longer within the certification, because employers felt like, well, what if that date changes, and am I certifying that that's when the person starts, because I don't know. These dates are always a moving target. And so I think that made employers feel a lot more comfortable taking out of that certification and put down further on the form.
Yeah, and I think in terms of just EVerify, in case you're also curious, since we're always talking about how they interplay, a couple of versions ago, they made it so that you could actually do an EVerify query, at least in terms of the way they calculated, up to 365 days in advance. I don't know too many people that are hiring that far in advance, but at least kind of hit the nail on the head in terms of saying, yes, you can have a future start date. And now at least that kind of matches a little bit in terms of how this works here. In terms of what else has changed, again, as I mentioned, they're very big into separating out address fields and having each one be its own unique field. Again, this is minutia, but it's very important because one of the most common mistakes in the old form was you'd enter an employer's business name but no address, because it was just employer's business name and address in one field. So hopefully that'll work exactly the same. The state also has the drop-down box, so that's also carried throughout the form as well. So hopefully there's not too many difficult items with this, but it is something that's important to note. Now we're at the bottom of the form, and we're at the re-verification, or the Section 3 section, I should say. And again, this is probably my least favorite, actually, now that I think about it, because it's so confusing and difficult because it's a multi-purpose use of the form. Now, the first thing I'll note is before it said updating and re-verification. Now it says re-verification and rehire. So why the change? Perhaps they're trying to emphasize, this is just conjecture, that updating is not always what you think of in terms of updating. It's not like, all of a sudden I'm a lawful permanent resident and I became a green card. I got to update this, or that name changes are absolutely required here, although that's certainly still the preference from USCIS. Instead, what they're doing is they're emphasizing the two most common uses for this form. And in terms of re-verification, that's the situation where you have somebody with expiring work authorization and you need to actually re-verify that they're still authorized to work before they expire. So you can complete this section here. You can also choose to complete a new I-9. That's always been the same. That hasn't really changed. But again, it's just something to keep in mind. Kristin, do you have any kind of best practice recommendation that you talk about, or just generally speaking when you're dealing with re-verification in terms of using Section 3 or using a new form? Is there a right way or a wrong way?
I don't think there's a right way or a wrong way. I think it's up to the employer's preference or status, as long as you're consistent. I think again, consistency is best when you're running your program. So if you always want to complete a new I-9, then you could do that. I think if you have space, it's great to use this box for re-verification. That's what it's there for, and it reduces having to, if you're on a paper staple another thing together or risk losing it. So particularly if you're in a paper process, as John said, you have to use the new form when you re-verify someone. So starting May 7th, when the new form becomes effective, if you're doing a re-verification, you can't do it on the old form. You must do it on the new form. Now, rehire is different. So if you're rehiring someone within the 3-year period and their work authorization is still valid, then you can utilize the old form and write in their new hire date, their rehire date, if you will, but that's a big no-no for re-verifications. And I think this section in terms of changing someone's name, am I supposed to? I agree with John. I think it's a good practice if someone approaches you and says, and usually it falls more frequently on the female gender, someone's married, divorced, et cetera, and they're changing their name again, then you can reasonably ask for those documents to document their change of name or why they're changing their name, but you don't have to, it's not, as long as, there's a reasonable explanation, you don't have to dig into or look at anything, and I would encourage you not to do that in that instance, or you could get in trouble, perhaps, I guess, with the Office of Special Counsel. But in terms of, what else was I going to mention on that? On the re-verification, also, with DACA, I think the handbook takes into consideration some of the people that may come to you with a brand new identity. Okay, so it's not just a change of name, but they have, it's a new identity and they're presenting new documents. In that instance, then you must complete a new I-9. You should not use the re-verification section for that purpose, and you would want to complete the new I-9 for that individual. It's not a requirement that from an I-9 perspective that person be terminated. The implication would be that they have used false documents or made some type of false attestation on the I-9 previously, but there could definitely be corporate documents that would perhaps dictate that person, may be terminated. And I know many of my clients do have that in their policies, that if an individual has used, false documents and that is revealed, then that they are terminated for that action. But the I-9 rules do not require that.
Great, thank you. And I think it's worth mentioning, too, that there's the M274, which is kind of the I-9 Bible. It was also updated, and you can find in there the very specific instructions that Kristy was just talking about in terms of the new identity. Did you have a question?
Yes, you could do a new I-9 in that instance, yes. The question that she asked, if you have someone who is in H-1B status or L-1 status for that matter, and they become a lawful permanent resident, are you required to use the re-verification box that we're discussing, or may the company choose to do a new form I-9? And so you're not required to use the re-verification box. You can do a new form I-9.
And as always, as they say, the mantra in I-9 compliance, if you do it that way once, just do it that way in all such situations, just to maintain the consistency. So let's see here. The only other thing, again, minutia, we now have a print name field in Section 3 as well. Before we didn't, so people would have to kind of decipher what the scribble was in terms of the person's actual name. Now we have a print name field. What happens if you miss it? We don't know. Hopefully, in terms of the new penalty guidance, which they've been talking about it for a very long time. We anticipate sometime, perhaps this summer or fall, they will actually have new guidance that will match in terms of what's a violation, what's a fine, what's not, but we don't have that just yet. So just a minor little note, again, it says page 8 of 9, so there's 9 pages in total, and we're about to go to page 9, which is the list of acceptable documents. And one thing I'll just mention at the very onset here in terms of this, it says all documents must be unexpired. And that's one of those things that's just so hard if you're dealing with somebody who has, for example, an F1 student and they're eligible to extend their EAD via the STEM, and they say, but wait a minute, I have an expired EAD. I also have this other document that says that I've applied, for a STEM extension. Is this acceptable? And the answer is yes, it is, even though it's expired. So it should be almost like all documents must be unexpired and like with little tiny print with a few exceptions. So, again, it's just something to note. But again, it's remained the same in terms of its meaning and import. One thing that I will say has changed is we've got two little areas. One is on List A, which is the section where we talk about the foreign passport and the I-94. And just in the interest of time, I won't go over that too much because I want to get to a few more slides. But one thing I would like to point out is the Social Security account number card, or Social Security card. This has changed a little bit. We now have examples of cards which are not acceptable. And Kristin, I wanted to see if I could just get you to kind of walk us through why aren't these acceptable? When as an employer would I see any of these particular types of designations on a card?
When you see this designation on a card, that typically means that someone is required to have some form of work authorization in order to be authorized to legally work in the United States. So for instance, your H-1 example that you brought up earlier, their Social Security card is going to have this restriction, and it is not an acceptable document for a List C document.
Yeah, exactly. So again, just something to note. Otherwise, the list of acceptable documents hasn't changed. They actually couldn't change them in terms of the way that they work right now. If we have this new bill, who knows what we're going to see here. We'll probably see a very, very, very different list of documents. But this is pretty much the way it is now. So latest news from USCIS, I think we already covered this in terms of the requirement. There was some ambiguity in terms of rehires, in terms of, do they have to use the brand new form? Can you actually complete Section 3 of an old form if you rehire somebody? And they clarified that in certain circumstances, it's within 3 years of their hire date, their employment authorization hasn't changed, and there's room for it, obviously, the more practical notion, then you actually can use the old form. In some of the guidance and documents, they were indicating that wasn't the case, so they clarified that, which is, again, just important to note to get this right. I want to spend just a few minutes on electronic I-9 systems, since we were talking about that before. And in terms of the impact, I think the real obvious impact is, we have a deadline coming up. It's May 7th. And if your electronic system is not able to have the new I-9 form, then what does that mean? Well, it means most likely you're going to have to go back to paper. You're going to have to find some way to use that brand new form. And I should note that actually the whole reason, at least the stated reason, that we even had a 60-day grace period, it was, again, at least as they recognized it, electronic I-9 providers need time to actually update their systems. You might think, well, it's no big deal just to update an I-9 system. Well, yes and no, because there's actually a lot of different rules in terms of how the form must work. And so one of the things, if you're using an electronic system or contemplating one, I think another huge point is to make sure that your system has error checking for the new fields, that it knows that this is an optional field, that it knows that maybe you need to enter NA or not enter NA. I mean, these are the types of things which, again, minutia, but ultimately we want to make sure this form is completed correctly the first time, as they say, kind of one and done. That's one of the areas that I think is definitely important to recognize as well. In addition, and I think this is something that's new, and Kristin, I'll ask you in terms of just getting your opinion, because we don't really know yet, but we now have situations where you actually, as an employee, might be entering a foreign passport number in Section 1. There probably is one in Section 2 as well. How important is it for those two items to match? Is it a problem if they don't?
I think it's important for you as the employer that's looking at the documents to try to match them up to make sure that they are reasonably genuine and appear to be legitimate documents and match the person that's presenting them. So, I think that's an important facet to kind of do that cross-check.
Yeah, and I agree. It's one of those things that's, you want to make sure you have consistency across the board. There's other different types of checks which systems already do in terms of making sure that the same Social Security number is not being used multiple times. So these are the types of things that can help you in the long run, especially if you're going to EVerify, and it sounds like we're all going to EVerify. So again, something to keep in mind. The last point, in terms of too much automation, you might think, well, gee, I'm using an electronic system because I want automation. I want to make this easier, and I want to make it painless. But I think as we kind of alluded to during the preparer-translator discussion, you can have instances where you perhaps go a little bit too far. And I want to highlight this one because it comes up quite a bit, is you might, for example, have a system that automatically limits or restricts the documents in Section 2 based upon your attestation in Section 1. Now, this might make perfect sense. Why bother showing a green card if the person said they're a U.S. citizen? Well, what if they chose the wrong box? And that, unfortunately, has happened. We've seen situations where employers essentially might actually turn down good documents simply because the system was a little bit too smart for its own good. So again, if you're doing your due diligence, you're looking at these types of systems, it can be automated, but it has to also have the intelligence to know when enough is enough. And I'm reaching, oh, there's a question?
In that scenario, you would just imagine if that was on paper.
Yeah.
They would have tested one thing, and that's their attestation.
Right.
So they did it wrong, but they attested to it, and then they give you documents, and you accept it that way. Is that how it?
No, and that's an excellent question. So what you would want in that situation to do is you kind of balancing act. So you're saying, you know what, you said you're a U.S. citizen and you're showing me a green card. I can't take that. I can't accept that. So the system should stop you and say, you know what, you can't do that. But it has to walk you through and say, you know, maybe you chose the wrong box. So again, you want to make sure it doesn't allow you to go all the way through, but you don't want to ultimately restrict anybody's choice. Because that's ultimately what this is all about in terms of document selection. The employee gets to choose anything as long as it's actually appropriate for them. We have a few minutes left, so these are just best practices, and I think a lot of them are kind of obvious, but in terms of policies, we've been talking about this form in some detail. Kristin, do you have just some examples of things that you might indicate to your employer clients in terms of what you should do, how you should update a policy? What do you do if you don't have a policy?
Well, in terms of updating a policy, you want to make sure that it's referencing the correct form that should be used, the current form that's in process. And you would want to ensure with these new fields that have been added, your best practices and how you're going to, just as John had said, we're going to write NA across the board, even though the form is unclear, it says must, may, et cetera. What are you going to direct your staff to do that handle the I-9 completion for you? And training in carrying out that policy. It should be written into your policy, and in my opinion, should be done by an experienced immigration attorney or a labor lawyer that is familiar with I-9 and compliance issues that can properly guide and steer your team. You definitely want to also in your policy have when you're going to complete the I-9, because just as John said, consistency is key. You want to do it consistently across the board for your entire employee population. Are we copying documents, not copying documents that are being presented? That's also very, very important to be consistent and as it is carried out across your team and across your employee population. How do you treat remote hires where perhaps maybe you don't have an HR representative to complete the form I-9? You want to walk your staff through that on how you should complete that. You also want to ensure that your I-9 policy has a purge. We heard Dan, the free lunch. You don't want to miss out on the free lunch, and so you want to be sure that you have that as part of your policy, and of course that you have the date parameters correct in terms of when you are purging your I-9s. How you handle if you are an EVerify employer, how you're going to handle tentative non-confirmations or final non-confirmations. I also think a policy should have like an escalation clause. If you are an analyst that is doing this, and you encounter this problem, who's your next point of contact? From there, who's your next, point of contact to ensure that there's communication and consistency among the team. I also think it's important to, someone said, are we going to use the re-verification section? Are we going to use a new I-9 form? I mean, all of these seem like little things, but it's so important in the context of the I-9 and in context of treating your employee staff consistently.
Yeah, one of the questions that I've heard a lot in terms of, well, we have an I-9 manual, we have the M274, EVerify has a manual, why do I need another manual? And I think the obvious answer is Those are very long manuals, and they don't apply to you. So much of I-9 compliance is, well, you can do it this way, you can do it that way, just do it consistently. But you ultimately have to decide, once you've spoken with counsel and you realize how your particular organization works, how you're going to do it. And then you have to follow it. And if you're anyone here, I'll do a plug for my next panel. We're going to be talking about general counsel compliance stuff, and compliance policies in particular are going to be very important in that discussion as well. So we have, I think, a little less than... Actually, so here, yay, we're at the end. So this is all the things that we've looked at, and I'll dive into the final slide because we do have 4 minutes left, and I'll be happy to take questions. Yes, sir. That's a very good question. I'll repeat it just for the recording. So we had mentioned earlier that you should make sure that the employee received the instructions. The gentleman was asking in terms of, does the employee get to actually take it with them? Is there any kind of attestation that goes on? And as far as in terms of what is actually required, you just need to, again, it's almost like a good faith effort. You need to actually do this. You need to show them the instructions. I don't necessarily recommend that they take the instructions with them. The I-9 form is really an employer form. The employer owns that form. There is a kind of an exception in the instance of an electronic system when they do an electronic signature that the employee can get a receipt if they ask for it. That's kind of a slight little nuance there. But otherwise, there's no requirement. It's not like ICE is going to come in and say, well, I don't see, how do you prove this? They're going to talk to you. They're going to say, well, what's your process? What's your procedure? And if at least you have it laminated, for example, or it's in your policy, then at least you can prove it. But at least we're not up to that degree of duty. Any other questions? Yes, ma'am.
I have a question on...
Yes.
I wanted to get your thoughts. Last few weeks, it says list of acceptable documents, and I've had a few clients come to me with list C, and it says in big bold the lists of not acceptable documents at the top. Have you seen?
List of not acceptable documents? I haven't seen that.
Basically, it says, you can use the social security and list says this. So
yes.
I've had lots of clients come and they're like, well, they don't read the tiny words.
Yes.
Large words. And
Yeah.
So they come to me with the, H-1B social that says not valid for work, and he's like, look, I have this.
And that's what it says.
Document.
Well, that's a very interesting point. So, yeah.
Like, it's going to be a nightmare.
That's a very good point. I'll have to use that. If you don't mind, I'll use that in my future presentation. Yeah, because the fact that everything on this page means you can accept it, but except for those three. Okay, that's a very good point. I wouldn't be surprised if we do see problems with that. Any other questions? Yes?
Yeah, back in section 1, gets their I-94 not from CBP, so in the U.S.
Okay.
Down a little bit.
Yep.
And then they go on to fill in the foreign passport number and country of issuance. Does HR go back and tell the foreign national to cross it out? Is that a form of over-documentation?
Well, I would say that I don't think that's answered yet. I mean, oh, yes. Her question was, if you have someone who is in the United States, in other words, it's not in the scenario where we have the intercompany transferee who's outside of the U.S., so you have someone who's in the U.S., they extended, say, their H-1B, but they go on to complete the OR section and provide the foreign passport number and country of issuance. Is that over-documentation? And I don't think it's over-documentation in the sense that it's not on the section by the employer where they were, entered that data on list A and across the board in John's example, A, B, and C. But it's a fair question. It's not something that I saw that was in the handbook that addresses that. So I don't think it's. My first thought is I don't see it as a negative at this point. I mean, John, do you have a different opinion?
No, I don't. I think, over-documentation goes to the fact that you as an employer are actually requesting for more than is required. And since, at least in the hypothetical, here they're just entering it. Now, if you decide as an employer, you know what, we don't like this because it's going to be a red flag and we want to be corrected, then I think the premise of your question is correct. The employee should be doing it. That's always another I-9 rule. Employees should make all corrections to Section 1.
So you think as the employer, if they're filling out this and they mark 2, and I mean, you're Oh, do I keep going? Do I write this?
I would say,
Let them?
no, I think if you're sitting there with them and they're filling it out and they're like, and you could, I think you could correct them and say, oh, that's, you know, that's not required. You don't have to complete that in that instance.
And I think with that, we've reached 3 o'clock, so I think we're done. Thank you very much.